The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. We are here today on our case number 1, CA JV170443, Daisy T. versus Department of Child Safety et al. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to use time, you're in charge of keeping track of it for yourself. The clock on the podium reflects the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if you would open by giving us your name and the name of your client for the recording. We've read the briefs. We've looked at them again, this time around after our first conference a few weeks ago. We've also studied the record, and we've discussed the case in our conference. So with that, you may proceed.
All right. Thank you, Your Honors. I'm Florence Brummer. I'm representing the appellant, Daisy T. She's present today with L.A., as the court will know L.A. from the briefs. I thought I'd start today with the court's questions in the oral argument order. The first one was
Counsel,
discussing...
if I could actually ask you something first to frame
Sure.
your response to the first question.
Of course.
And in that question, we asked about the specific fact findings below. If you could set the stage for those fact findings by explaining what your understanding is of the legal framework within those facts. What was the standards? What conclusions of law were required that the state had to establish?
Sure. So regarding, as the court knows, there were two grounds that the court found on the termination. So one was the neglect, and for the neglect, the standard that the court would have had to find.
You know what?
You might focus on the other.
Yeah, let's focus on the second ground.
On the timing.
All
here.
right.
The timing
Okay.
care. That's a
Sounds good. All right. So on the second ground, the time and care, the elements that the court would have had to find if there was a substantial likelihood that mother would not be capable of exercising proper and effective parental care and control of the girls in the near future, and it was the state's burden to prove that. And the court had to find this by clear and convincing evidence. Did the court want me to go more than that, or regarding what the standards were?
well, you know what? Why
Okay.
don't we go ahead since I understand there are multiple elements to the timing care, but if that's where you'd like to focus, why don't we get to our first question in the order then?
Sure. So the question in the court's order was, what are the specific factual findings that the court made in severing mother's parental rights to her two older children based on the 15 months in care? I went right back to the court's minute entry, and I don't know if I find any specific factual findings that the court made in the minute entry. It seems to me that the court just basically said what the standard was and said, this standard has been met and the ground has been met, and I find that there's clear and convincing evidence, the end. What those specific factual findings are, I'm not entirely clear from the order. And in that case, I would say since the court did not make those specific factual findings, that on that ground, that should be reversed.
Is there a law for that proposition?
I think the law is that that we have cited in the brief, and then we went back for the reply brief as well. I think Jordan C. is a good case for that. I think the recent case of Alma S. has some very good law that this court has recently set forward.
So,
regard.
what I understood you to say is that the court must cite the facts on which it makes from which it concludes that the statute has been met.
Sure, yeah.
And so you'd say Jordan
I think
says
Jordan
that?
C. says that, and then Alma S. was my understanding as well. I thought the Alma S. case was very similar to this case, almost with more favorable facts, with Miss Daisy having more favorable facts in her favor than Alma did in her case.
Well, that's a best interest case. And
It
We're
is.
talking about the
Sure.
statutory grounds,
It
I
is.
think.
And don't the statutory grounds just kind of, by stating that you are finding facts, just by the nature of the statutory ground, is there a requirement that the court, for example, list, I'm relying on the testimony from Dr. Gill or from Dr. Thal or from someone? Is that necessary?
Oh, I see what you're saying. I don't know that there's a specific case where it says that the court has to make those findings. Although I note that it appears that this court has concerns that maybe those findings weren't made and the court's not sure what the trial court judge relied on in this case. And looking back, I'm
But
sorry.
if we look at the record and find evidence that supports a conclusion that mother's been unable to remedy the circumstances, is that not enough for us?
That probably is enough for the court, although I don't think the court can do that in this case based on what the facts were. And I think that may be a reason why we don't have a good set of facts in the findings of facts and conclusions of law in this minute entry.
All right, why don't you walk us through those facts in the
Sure.
record that establish that mother has remedied the circumstances?
Exactly. Absolutely. So, as the court knows, wasn't the mother's burden, but the evidence that was presented supported mother's case that she remedied those circumstances and that there was no information that in the immediate future that this would not continue to that mother would continue to succeed. We had the two reports from the two doctors in this case, Dr. Gill and Dr. Thal. I always thought Dr. Gill's report was interesting and his testimony was interesting. He seemed to be more concerned about mother's traveling distance to work than anything else regarding her parenting. He also set forward and confirmed that when she had the diluted UA, that she immediately followed it up with a clean hair follicle at her own prompting. Dr. Gill also verified that the bond between the girls and Daisy were strong and there was good reports on the parenting throughout and that mother had shown a period of sobriety. Also, Dr. Gill and other testimony, like the case manager, other sources, confirmed the things that were set forward that mother had to do, which she completed with success. The period of sobriety. Not only did she submit over 100 clean UAs, she also attended AA meetings, NA meetings. Mother testified how important those meetings were to her, how she was
Let's say we
succeeding.
agree on the sobriety and the
Sure.
and the substance abuse issues. I think the greater concern, and I think this was in Dr. Gill's, it may have been just in Dr. Thal's, but there were concerns about the ability to maintain or to provide a safe and stable home environment. And there was clearly some concern about this relationship with the father of the baby.
Yes.
And statements that had been made about potential ongoing interactions with that man. Can you address those facts, please?
Sure. So I think the evidence that was really more about the ongoing was that mother had a child with him. But besides for having the child, I don't know that there was really a whole lot of evidence that she was continuing a relationship.
Wasn't there some evidence, at least, that she intended to have him maintain a relationship with the new child, and that he would be around the other daughters as a result? Is that not correct?
I'm not recalling that. I know that there was some testimony that he had watched the baby when she was about 4 months old, and there was some conflicting testimony about what that occurrence was. I know that the position of the state was that he was babysitting the baby on his own, but there was testimony from mother where she said there was a group of people, he wasn't alone with the baby, and it didn't seem like anyone had any evidence that mother had a continuing relationship with him. And I believe, in fact, the caseworker had stated that she had no evidence that mother had any sort of romantic relationship going on at the time of the trial and any time like in the
But a
recent
romantic
past.
relationship's different than, is this person going to be involved in the life of the new baby and in the lives of the other two daughters? And it seemed to me, my recollection, I don't have it right here in front, that there was some suggestion that would be the case. And I guess what I'm interested in from you is, Dr. Gill had said a lot of positive things about mother, but I think his overall conclusion was that she would be, he didn't believe that she would be able to provide a safe environment. And so I guess in the realm of, is this an abuse of discretion of his rationale for thinking that she would be unable to provide a safe environment, what is there that would give us a reason to disagree that there was at least a basis for what the court decided?
Sure. Beyond all the evidence that was provided, and I know the court's very familiar with this record, I think that we have a case study that we can use that's actually in the case, that the department agreed that the baby would be returned to mother. This is the baby who the father is this gentleman that we're talking about that everyone has the concerns about. So from the baby's perspective, nobody has any concerns.
But isn't there a big difference between daughters, the older daughters who've raised concerns and said they're uncomfortable around this person, and those concerns presumably haven't been raised with the baby. So the fact that there's no issue involving the baby doesn't seem dispositive of whether there's a continuing issue as to girls who've said that they're uncomfortable with having their stomach rubbed while they're asleep, and that they're clearly uncomfortable around him. So I'm not finding a direct, the fact that the court may not have done anything regarding as to the baby doesn't necessarily establish that you have to go down follow the same path with the older daughter.
Sure, I agree. And I think that there's plenty of cases out there where some children are terminated, some aren't, some go in a guardianship. So I don't think you can say automatically mother wins on this point. But I think it's very compelling information because I don't think the baby is in a different situation. The age is a little bit different, but it still concerns that she's a female. And if this guy, we never really had, I know we didn't have anything that said, here's what happened exactly, but the one of the doctors believed there might have been some grooming behavior involved. So why wouldn't you have that same concern with the baby?
Can you point us to cases that talk about what you call a case study here, where you have where you have an order of severance, a hearing, an order of severance, and our cases say that time and care, the circumstances you look at are at the time of the hearing. Are there any cases that address this situation where there is another decision 6 or 7 months later?
Mm-hmm. When you say another decision 6 or 7 months later, are you talking about with the older girls? Or
the younger child.
As to
The
additional
contrast
children.
here between the
Okay.
older girl's decision and later.
Sure. I see. Not that I can think of or found, although even though Alma S. was a best interest case, I thought the reasoning could be applied in this case regarding that where relief is appropriate on appeal, where the trial court findings are not supported by the evidence. And in this case, it appears that the trial court in this case ignored facts that were in mother's favor and just went ahead and looked at all the old stuff. And even when you look at the appellee's brief, and I want to give myself a couple minutes for rebuttal, so I'm going to try to wrap up this point quick. But when you look at appellee's brief, A lot of it is the old stuff. This is why the kids were brought into care. This is what the kids said about the old boyfriends, not focusing on any of the things that the mother had done that were undisputed, that the mother did, that DCS said, this is what you need to get your kids back. It was all the old stuff. And if that's the standard, that whatever happens when the kids are brought into care, there's no need to ever have an appeal.
But assuming we agree with that, and isn't there at least evidence from which the court could reach a conclusion that she's been unable to provide a safe environment if there's evidence that the kids are bothered by any involvement with Jay, and that in the court's view, mother continues to have is not prohibiting Jay from having from being around the kids? Why isn't that enough to say she hasn't now created a safe and healthy environment for the daughters?
Sure. I would disagree that those are the facts. I don't think that's what was testified to by the case manager or mother or her sobriety counselor. I don't think anyone was saying that was the case.
But is there not any evidence that mother said that he will continue to have involvement with the new child, the new daughter, and he will be around the other two daughters?
I'm not recalling that at all. Like, that is such a bold statement. And in fact, I would be very surprised if it's in the record, because if mother got the baby back and the court released her from the dependency, I don't know how that could be a finding of fact in it. And that was not my understanding from how the facts were reading, that he was going to be having any sort of substantial contact. I didn't even feel like there was going to be much contact at all. Can I reserve my last 4 minutes for rebuttal? Thank you.
Good morning, Your Honors. May it please the Court, my name is Amanda Adams, and I represent the appellee, the Department of Child Safety. Your Honors, this Court must affirm the termination order terminating mother's parental rights to Tanya and Isabel on the 15-month out-of-home placement ground, because reasonable evidence in the trial record supports the Court's explicit and implicit findings on this ground. Namely, that her continued relationship with a known child abuser, her poor judgment, and her inability to recognize the child's needs and place them above her.
What is the most compelling evidence that there's a continued relationship, and that the continued relationship with Jay will include him being around the older two daughters?
Your Honor, throughout the record, there's evidence that mom continued a relationship.
Can you point us to something specific in the record, please?
Your Honors, Exhibit 7 and 8, mother told DCS, this is February 2017. This was after Tanya had disclosed the possible grooming behaviors. The DCS case manager spoke to mother about these possible grooming behaviors. Mother still told DCS that she was planning to allow Jay to have contact. She said, I told the children we're not going to be together, but he's going to come hang out on the couch, and also that he would help her with the baby. And you see this occur in April of 2017. He was at the hospital when she had the baby, and later that month she left the baby in his care. Whether it's romantic or not, it's a relationship.
Was any of that contact with the two children that are the subject here?
In April?
Yes.
No, that was with the infant.
Is there any evidence in the record of when they last had contact?
That would have been April.
No, when the children were last placed in contact with the man.
That they
older two children.
They did not have contact with the man during the dependency because they were in DCS's care. I apologize. Is that your question?
I wanted to confirm that.
Okay. The concerns that the department had was that
He was
even,
still having contact
even
with
with their history, Mom, the DCS case manager, told Mom as early as April 2016 that he had a 1997 conviction for child abuse. She went over, the case manager, went over the police report with Mother. At that time, Mother said that she would not be in a relationship with him. Over the next 8 months, she misled not only DCS, but the court to believe that she was not in a relationship with him. Instead, she continued the relationship, and there's evidence in the record, Your Honor, that she was reporting to her substance abuse counselor, and this is at Exhibit 14-1-00252, that she referred to him as her boyfriend as late.
Assume there hadn't been any kind of allegation of rubbing the stomach, anything involving the two older daughters. Would it be enough to say he had a conviction in 1997? We're quite a ways down the road now, and there doesn't seem to be anything post-1997, and the 1997 incident doesn't seem to bear on whether Mother's rights to the baby should be severed. So why is this 1997 conviction of significant concern?
Your Honor, I would agree that it's a significant concern because of the allegations that Tanya did raise. If those allegations would not have surfaced.
Aren't those very different allegations than what was alleged than the 1997 incident?
Well, I think from the very beginning, and I think I misspoke, is from the very beginning, DCS was concerned about her relationship with him, although his conviction was in 1997, Your Honor. And I think it goes to her pattern of engaging in relationships with dysfunctional men, and also not realizing the risk that poses to their children.
Then you start getting into the inconsistency between the result with the infant and the two older daughters. If it's just a pattern and she's going to have that same pattern, why do you not seek the removal of the infant?
Well, Your Honor, DCS did remove the infant, and at the time of the trial.
Did DCS object to having the infant go back to Mother?
Your Honor, that would require me to talk about facts that are outside the record. If you'd like me to, I will. I have limited knowledge of
That's okay.
Okay.
It's more tangential. Go ahead.
Well, it's been
but
filed
I
in this
will.
court.
Yeah.
But I will go back to at the time of trial, the infant was out of Mother's care. At that time, DCS, I was not seeking reunification with Mother at that time, but
Didn't the case plan change the trial either same day or same time frame as the trial? There was a status conference or whatever you call it, at which the case plan for the infant was changed to reunification.
I'm not aware of that. It may have been shortly after, but the fact that the child was eventually reunified with Mother several months after the final order was entered is not evidence that the trial court's decision to terminate Mother's parental rights is erroneous, based on the evidence that was presented to it at the time
Is
of
there a
trial.
case on that?
Your Honor, yes, I do have that. I'm sorry. The case that I was relying on is the general rule that this court put forth in Southern Pacific Transportation Company versus Lewick, 111 Arizona 560, and that's at page 575, where as a general rule, the appellate court can determine a cause only upon the record of the lower court.
Right. And that's generally true. But I'm wondering if there's a case that talks about two sets of children, one parent, different rulings within 6 months of each other, whether the second one, as a practical matter, should bear on review of the first?
Your Honor, I'm not aware of any, like, when the second child is subsequently returned to the child. I do have a case, and that is Maricopa County Juvenile Action Number JS5209-143, Arizona 178 at page 185, and that is App 1984.
What's the Arizona site?
Oh, I'm sorry. 143.
143
Arizona 178.
Okay, thank you.
The fact that a parent is able to minimally act as an adequate parent for one child does not mean that the parent would be able to care for other children.
That seems to go to evidence that's in place at the time of the severance hearing. And it just as a matter of logic, it's hard to say that we can find that somebody abused their discretion based on something that wasn't before them.
Correct. Correct. But even at the time of the hearing, Your Honor, these were 3 individual children with individualized needs. The infant had only been out of mother's care for 2 months. The older girls, Isabel and Tanya, had been out of care for, at least 19 months. There was.
Let's talk about the 15 months timing care. I want to ask 2 things, but to start with, could you tell me what you understand with regard to the elements that need to be proven, what the legal standard is, or what does it mean? What do you have to prove with regard to the circumstances that cause the child to be in an out-of-home placement?
Your Honor, under the statute, child has to be out of the home for 15 months.
So with regard to the circumstances that cause the child to be in the out-of-home placement, is that a dependency standard? In other words, is the court at the time of the trial looking to whether or not there are, at the time of trial, there is sufficient cause to find the child still dependent at the time of trial? In other words, whatever circumstances cause the dependency up front, do those same circumstances or sufficient circumstances to cause a dependency at the time of trial need to be present?
No,
and if not, what is the standard then?
No, Your Honor. The standard is we look at the circumstances at the time of trial, those circumstances that are precluding reunification. It's not necessarily a mere circumstance as the same ones as removal. And that's, in some cases, the circumstances can change. They could find out that maybe the children were removed for mental illness, but come lo and behold, mom's testing positive for drugs. I'm not saying that this was in this case, but that can happen. The circumstances.
But the subsequent circumstances, the testing positive for drugs, would be a separate but adequate circumstance for finding dependency.
Correct.
Right? So that's what I'm getting at. What is that legal standard? Is it the same standard as for dependency, not necessarily the same the identical circumstances, but is it sort of the same burden? The burden that you have to establish to find a child dependent is the same burden that you have to establish at the time of trial to support severance on this basis regarding the circumstances that cause the child to be in an out-of-home placement? That's the statutory phrase I'm trying to get at. What do you have to prove to establish that element?
So do the current circumstances on their own have to be sufficient to support a dependency?
Yes, that's what I'm trying to get at.
Your Honor, well, the dependency standard would be whether the parent is able to parent. So the circumstances you're looking at trial are also what are the circumstances that preclude this parent from parenting her child. There's also the additional element that DCS has to prove that there's a substantial likelihood that they will not be able to be capable of parenting in the near future.
Okay. As to those 2 elements, can you walk me through the specific factual findings of the court?
If you look at the court's minute entry, under the 15-month ground. There is the finding regarding the time in care, longer than 15 months. The court also cites to and incorporates DCS's factual allegations in the motion under 9B and 9C. 9C is the 15 months time in care, where the court reviews and finds and lists the diligent efforts that DCS made. If you look at the court's findings under the neglect grounds, the explicit findings in the minute entry, and also DCS's explicit or specific allegations in its severance motion, which the court also incorporated in its minute entry.
So do you take that, the court's incorporation of those in the minute entry, as the court adopting those as its own findings, or the court noting that those were the allegations made?
The court, in this case, adopted those as its findings. And, Your Honors, if you look at the court's findings and also the DCS, the specific allegations in the severance motion, the court found, despite reporting that she was no longer in a relationship with Jay, mother became pregnant by Jay and gave birth to his child on April 3rd, 2017. Mother has continued to demonstrate poor decision-making that places her daughters at continued risk of harm if they were to be placed with her. Given the girls' self-reports of abuse and grooming at male figures in their lives, it is particularly grievous that mother continues to choose her adult relationships over the needs of her daughters. Mother has not remedied the neglect which led to the children's removal. Your Honors, I do recognize that these are findings of fact that the court made specifically under the neglect ground. However, they're findings of fact nonetheless. Thus, the court can infer that those were implicit findings that also supported the 15-month ground time and care. It's not uncommon and for a court to...
There's certainly an overlap. Findings.
Yes, correct, Your Honor. So in looking at Reuben M., which does set forth the standard of sufficient factual findings required, the court's findings of fact, conclusions of law, taken as a whole, are sufficiently detailed to allow this court to effectively review mother's appeal in this matter. And based on the findings that the court made, there's reasonable evidence to support the court's findings under the 15-month ground, specifically that mother was unable to remedy the circumstances that caused the children to remain in care, and that there was a substantial likelihood that she would be not capable of demonstrating proper and effective parent control, care and control in the near future. If the court doesn't have any further questions, I will conclude.
Okay.
Thank you, Your Honors.
Thank you. Thank you.
Thank you, Your Honors. May it please the court, Florence Bremer. The court had asked what was the most compelling evidence, I think specifically regarding Jay. And I know there was possibly some statements mother made that Jay may be involved in the children's lives in the future, even if she wasn't in a relationship with them. If that's the finding that the trial court made to terminate mother based on the 15 months in care, it's an error under Jordan C. It cannot be a mere chance that mother will make a mistake in the future. There has to be a substantial likelihood that mother would not be capable of parenting. And she did everything. Besides, I think the court, I feel, was pretty satisfied regarding her sobriety issues, but she also did healthy relationships and boundaries classes. On her own, she did the DBT therapy. She managed the 3 children during the visits with no problems. There was lots of testimony from mother, from her sobriety coach, that stated the doctors, I think, did not have anything opposing what mother was saying, that she was not in a relationship, that she acknowledged that she has picked bad men in the past, inappropriate relationships, and she was on the lookout for that. And even in the trial court's factual findings, the
Are you
court...
saying it would not be enough if there's expert testimony that suggests that the kids are not, and the older children are not in a safe environment if they're exposed to Jay, and there's evidence from which the court could conclude that Jay is still going to be around? We're not just talking about she may choose somebody bad in the future, but if there's that evidence, why would that not be enough to survive an abuse of discretion standard?
I think that it depends on what this relationship is. If she is saying he's going to come visit his daughter sometimes, I don't think that's enough. If she says we're getting married and I don't care that you girls are uncomfortable, that's different.
She's not going to marry him, but if he's going to be around these two daughters who say they're uncomfortable, and the experts are, and the court's disbelieving that any suggestion that he's not actually going to be around a lot, and you have expert testimony that says that's harmful. You would agree there is something to that effect in the record?
Well, no, I think, this is what I'll say, Your Honor. I don't think that's what mother said at trial, that Jay is around no matter what. But taking that as a hypothetical, I think that just the fact that if he was going to come and visit, I don't think that's enough based on Jordan C., and definitely not enough on the best interest. I'm down to my last minute. I'd ask the court to please compare this case to Alma S. In my mind, as I was getting ready for this, I said this case is more Alma S than Alma S's. The facts were so similar, the best interests, determinations that this court made regarding it. As this court knows, IW is not willing to be adopted, and the trial court's finding that the termination would further the case plan of adoption, it doesn't. If IW is not willing to be adopted, it doesn't. I will rest unless the court has any other questions.
I think we're good.
All
Thank
right,
you.
Thank you.
Thank you to both counsel for your briefs and for your argument. We'll take the matter under advisement and issue a decision in due course. Now we will adjourn.